Good afternoon, everyone. Based on the feedback we got from the first 3 days, we'll be waiting a while, maybe giving people like 5 minutes to join before we start. So we will be starting at 2:05 so that we can allow other people to join before we start. Thank you.
Olumide. Hello, sir. Mr. Olumide, please unmute yourself.
Sorry, I didn't know that I didn't. Anyways, this is just the beginning of the slide. So, sorry, I didn't unmute myself. So, like I said, we're looking at the cases on privacy. Unlike all other subject matters, the courts have identified certain decisions that are given direction to those subject matters. In land, we have Ali Kuchebi and some other decisions, Okumagba. In local standard or jurisdiction, you find Kedilim. So many decisions, so many subject matter areas that you would have found that the courts have repeatedly cited some cases as locus classicus. Even in fundamental rights, you have AG, Oyo, and Belu, where that is periodically cited for the right to life. But in privacy, none has been identified by the court as locus standi. For the court to have given a decision in one of the cases that this certain decision on privacy is a locus classicus, none. Even in the cases, none has been repeatedly cited, no decision. I have, over time, studied so many decisions of the court, but you will not find one that is repeatedly cited or relied upon by the court. Sorry, excuse me. Okay. Now, also, for the academics, there is no decision that the academics have agreed or have even relied on as locus classicus. No. In the articles, in the books, for privacy, you won't find. Ultimately, no decision has given that kind of direction that we want for privacy to take. Like if we are, yesterday, 2 days ago, so many of the most of the facilitators said something about testing the law. Even the judge that came said testing the law. It shows that our laws have not been tested so much as far as privacy and data protection are concerned. So no particular decision has given clear direction on how privacy should be approached or how privacy should be redressed or what the way the court should even look at it. That is not saying that there has not been any decision where privacy has been to a large extent addressed. But in terms of providing clarity, in terms of providing direction, in terms of providing authority for privacy or data protection, none that you would readily rely on as locus classicus. Except after this training, we want to start looking at some decisions as locus classicus. But as we speak, on the strength of the cases, on the strength of the publications, on the strength of the arguments that we've had in court and outside court, no decision yet qualifies as locus classicus. This case is very, very, it comes in very handy anytime I'm talking about privacy, because I didn't even know a case like this existed where the court had to make certain salient pronouncements on the value of privacy. I didn't know that. I mean, there are actually two. There's a sister case. That one is Naya and State as well, where a court of appeal judge said that privacy is the most valuable of all rights. That was a decision by Justice Agim. He is now a judge of the Justice of the Supreme Court. So, I mean, in that case, it was a criminal case, yet the court found the violation, the police violated the victim's right to privacy, and the court had to declare on the value of privacy. We might argue it, that no, right to life is more important, or other rights are more important. But privacy is linked, intrinsically linked to all these rights. So one way or the other, the value of privacy can actually be seen in its link and its interplay with other kinds of rights. Now,
what case law exists in Nigeria on the interests protected by privacy? Unfortunately, these interests have not been adequately analyzed judicially or even academically in Nigeria. The first one that is most common is that privacy protects intrusion or prevents intrusion into somebody's seclusion. I don't want to be disturbed. My private space should be protected or should not be invaded. My personal matters should not be invaded. It should be kept the way I want them kept. That is what everybody understands as privacy, or that's the most common privacy interest that has been protected. Intrusion. We don't want people to invade. Like we always say, don't invade my privacy. That's the common one that everybody knows, and that's the common. It also speaks to privacy of home. When people go into people's home, whether law enforcement agencies or whoever, we can easily identify when this kind of privacy interest is breached or violated. The second one is appropriation of name or likeness. This one has not been so litigated in Nigeria, but there are two decisions where this has been mentioned. In the course of the training, I will touch on those decisions. So this one is just speaks to the unauthorized use of somebody's name or image for commercial purposes. So even though you might call it other thoughts, you might say, some people have litigated, even me in the past, I've litigated this under copyright. But when you look at it, putting somebody's face or putting somebody's likeness out there without the person's consent is a violation of privacy. It now becomes worse when you now use it for your own commercial gains. The third one and the fourth one, they are the most controversial. Public disclosure of private facts. This sometimes is it has a close relationship with defamation. Just that in defamation, the publication has to be false, the imputation has to be false. But in this case, the publication or the implication is not false. You are publishing somebody's fact, somebody's story, somebody's information without the person's consent in such a way that the person finds very offensive or objectionable. I'll give certain examples in the course of this training, but this is not so common. Even in Europe, even in the Western world, because people will always prefer to go for defamation. And we forget that defamation has certain defenses that sometimes it is difficult to wriggle out of it. I'll speak to this very soon. Now, false lie. This is another one that is also close to defamation. You are giving somebody a false narrative, which is damaging to his reputation. You are making false or misleading statements, but they are not defamatory. But there's a thin line. Those statements are not defamatory because those statements might not necessarily reduce the person's reputation, especially for people who don't have reputation. It might not necessarily reduce, but those statements are false and they are damage. They can actually damage reputation. In this sense, speaks to somebody's privacy, somebody's self-esteem. Now, let me move. Now, this one, like I said, is the most popular one. And we all know this case of NDPT and Okonkwo, where the patient refused blood transfusion and died, and the doctor was charged before their disciplinary committee. The matter got to the Supreme Court, and in the course of deciding the doctor's liability, the court pronounced on the patient's right to refuse blood transfusion as connected to his right to privacy. In other parlance, we call it right to bodily autonomy, or right to personal autonomy, or bodily privacy, or physical privacy. I mean, the right for anybody to say, my body is my private enclosure, and I'm entitled to decide what I want to come close to my body. blood transfusion, whether on the basis of religion or other subject matter. I don't want blood transfusion. The Supreme Court now, in that case, describes, I really particularly say define, because the definition is not elaborate enough. The Supreme Court in the case define or describe the right to privacy as the right to protect one's thought, religious belief from coercive and unjustified intrusion, whether body, whether thought. Your right to protect it from intrusion is governed by the right to privacy. And that is where you can see unjustified intrusion. Intrusion really doesn't have so much problem. There are so many other cases too, where people have intruded or invaded somebody's privacy, and it was easy to spot. The violation. Now, this is the second one, which is the appropriation of images or likeness. We also have a decision, Banire and NTA Star TV. In that case, a media personality sued another cable company because they used that picture to advertise their product on their billboard without our consent. So this is where lawyers, practicing lawyers, litigation lawyers need to be circumspect. They need to really watch the course of action that we want to take to court. We might have a good case, but under a wrong course of action. Because left to me, the lady had a good case, but maybe they went on a wrong wicket. They sued for violation of image stroke intellectual property rights. And that was where the problem lied. Image right, if you had been image rights and they had brought it under, okay, anyways, look at what the court said. The court said image or publicity rights refers to a person's right against misappropriation of likeness, everything I said under this. And the court said, put simply, it is the right of a person to control public's commercial exploitation of the person's identity. In Nigeria, the court said there are no specific laws, just because our laws are not developed. But image rights, there are no specific law governing image rights. But the closest law that can be considered is Section 37, known as the right to privacy. Unfortunately, the lawyer did not have the benefit of going through this procedure, going through Section 37, and hammering on the violation of that privacy interest, which is appropriation of image or likeness for commercial purposes. Section 37 provides for it. And I'm glad the court found a nexus between these two. But unfortunately, they had got to the Court of Appeal. Maybe they had got to the Supreme Court. Maybe the Supreme Court will see it differently. But they went under intellectual property and image. In other words, the course of action was not well with respect to the counsel, could have been wrapped better around Section 37, and maybe they would have had their reliefs or their claims. Now, there's another case on appropriation of likeness. This is by Courtney and Kilani. In the case, by Courtney is an aviation company. They used the picture of somebody who was just a traveler who was at the airport at a certain time. They took his picture, maybe alone, and they used it to advertise their product on the airport billboard. It sued them rightly under Section 37. And this is where the court interpreted privacy to include the exclusive right to use photographs, which should not be used in making an advert without the person's consent. And this just speaks to that, and it says the appellant breached the respondent's right to privacy. This speaks to this privacy interest. Although this appears to be the only Court of Appeal cases on the use of image or likeness to advertise somebody else's product. The other privacy interest, public disclosure of private facts. This one, people have not litigated it. In our firm, we have about 4 matters that we're currently litigating around this. In those cases, a celebrity, somebody wrote something about a celebrity on social media, that the celebrity was having a sexual affair with someone. The celebrity approached us and wanted us to sue for defamation. And left to me, the problem we might have with Nollywood celebrities is that most of them have had these stories around them, hovering around them, unrefuted. Some of them true, some of them even came to admit it. So normally, maybe this is me thinking, and maybe I'll throw it to the house for, subsequently. Normally, thinking about in the reasonable sense, the reasonable man thinking about Nollywood actors and actresses. This is me thinking. I am not sure they have that kind of reputation that you can launder from rumors around sexual affairs with themselves or with other people. I think Nollywood actors and actresses have this reputation of having sexual encounters with people, such that sometimes when you hear about a certain celebrity, actress or actor, you might not even take it seriously. It might not necessarily affect the person's reputation. They still do movies and we still watch. We still follow them on social media. We still, not the way I see it, I'm not sure that will really affect their reputation. That is one. Secondly, if you sue on the basis of reputation, if they have facts or they have evidence to justify it, that's a problem. Thirdly, if they come and show the person's, they in the witness box, destroy the person's character, then you're almost losing the case. Or they bring defenses of privilege, fair comment, and all sorts. All these defenses that are available to defamation, you might as well lose the case. So for us, we thought, because another thing we were told was that this celebrity had the person they rumored them to be together, they actually have a relationship. Maybe it is amorous, we don't know. Maybe it is sexual, but they have a relationship. So we thought, it is just better we approach it from the angle of privacy. Your relationship with someone is your private fact. Whether amorous or not amorous is your private fact. The person who has actually said it on social media is not a journalist. You are not a civil servant or a public servant that will say we are interested in. So we just put all those things together, and we're waiting to see how the courts will see these things. But whichever way it goes, the jurisprudence around this thing has to improve much more than what it is. Now, in this Okon and Obo, in a community, somebody wrote a libelous letter against a chief to the head of a municipal council, that the person was involved in activities that led to civil unrest in the society, in the community. The person, they were to court and they raised the defense of justification. And they had facts to prove that the person actually was connected one way or the other. The defense of justification availed them. But the court, even though this fact, I wouldn't say this fact or the fact of the case tallies with public disclosure of private facts in the sense that you want to litigate it. But the court made mention of this privacy interest in its ruling, and the court was not impressed that they used the defense of justification, although it succeeded. But the court of appeal wasn't impressed. That there ought to be a course of action that people can have, even though you have said something true about the person, but you have invaded the person's privacy, or there's some fact that the person doesn't want to make public, and you have, without justification, made it public. Now, the court said whether truth should, in all circumstances, be a defense is controversial, and the law has been altered in some jurisdiction so that the defense is only confined. You can only use justification or truth if the publication is for public interest or public benefit. Now, if the course is followed, that is, if this suggestion is taken in Nigeria, that is, if we limit truth to public interest cases, then it is introducing by an indirect way what we did not have in what we have not really litigated, a liability for invasion of privacy by revelation of embarrassing private facts. So the examples I will give in this case would be somebody who has HIV, and somebody writes a story around the person having HIV. The person cannot sue for defamation because the person will just come, the publisher will just come with the defense of justification. Rather, what you would say is, this is a private fact and it is embarrassing for you to have published it, and you have invaded the person's privacy. That is public disclosure of private fact. There's a decision in South Africa. A woman who had gone through about 18 IVF, had done IVF 18 times, unsuccessfully. Maybe a hospital brochure or another organization published that fact. The woman couldn't have sued for defamation because it happened. But the disclosure of private facts, and sometimes embarrassing facts, it's a cause of action that the person could explore under the right to privacy. The fourth one is publicity in the false light. This is also similar to defamation, and that was another cause of action that we used in our case. If you say somebody if you say an artist has been having amorous affairs with somebody else, or having sexual affairs, and the only fact you have is because they've been together or you've seen them on set or something, then you are giving the person publicity in a false narrative. And so the very popular cases, although in Nigeria, again, we don't have cases that fall directly on this, but there's this case that one can use to drive this narrative. Portland Paint and Olagiri. In that case, a company manufacturing paint, that's Portland Paint, published a calendar, their annual calendar. In one of the pages, they used the picture of the respondent, giving the public an impression that the respondent used this. They used the picture of the respondent's house to advertise their product, giving an impression that the respondent bought paint from them, used their paint to paint his house. He took them to court, and the respondent won under the right to privacy. And in the decision, the court said that the calendar created a false impression, giving the public the impression that the building was painted with their paint. But this case, or this privacy interest, is more effective when it is dealing with humans. When you publish stories, or you publish pictures, or you publish captions, giving false narrative. If I had known about this about some 10 years ago, maybe I would have used it. I tried using it. Okay, let me give you the scenario that happened. In 2011, I went to the Federal High Court. I didn't go there to do any matter. I went there to find out about our case. So I wasn't wearing wig and gown. I came out of the door, and EFCC officials were having a meeting. That was the time that EFCC used to come to the court in droves. They were wearing their red attire, and they formed a circle, kind of. I came out of the court in a way that looked like I entered their circle. that circled, and somebody from wherever took a picture that showed that I was surrounded by EFCC officials. I don't know. So EFCC published that picture on their website. And bloggers and anybody who had any story to write about EFCC just went to that website, picked the picture, and they used it. So in other words, all the stories around that time that bloggers and newspapers were writing about anybody who had a case with EFCC, they would put my picture in the midst of EFCC as their story picture. A friend of mine just saw it and called me. I didn't even know about it and asked me whether I had a matter to do with EFCC, whether I was arrested by EFCC. And I said, no. So he told me he saw a story that I was in the picture. So I went to see it. And I saw myself there. Yeah, I investigated it. And I remembered, I remember one of the, because many bloggers used it. So I took some of them to court. I remember one of the days I was in court, I was arguing with myself before retired Honorable Justice Candidate Johnson. My Lord saw that I had a cause of action. But my Lord thought right to privacy was not. Because I didn't want to do tort. Some people were saying, oh, I should do tort of defamation. Defamation still would not fly. Because the story, the caption was not my name. It was just a picture. And these people will come and use all sorts of defenses. They could say justification. I was in that picture. They could say, it's fact. They could argue so many things in defamation. That was the first reason I didn't go for defamation. Secondly, the number of years it would take for you to even finish trial. So I thought, oh, privacy, but I didn't even know this one at that time. This would have been a perfect course of action for me, a privacy interest that I could have litigated. Because that picture gave a false narrative. It painted me in a false light. It wasn't particularly defamatory. It wasn't. But in terms of privacy, yes, that was my best bet. Anyways, that's for false light. Now, what are the case law? Let's look at the case law on the elements inside Section 37. Section 37 has about 4 elements or 3 major elements. First of all, the privacy of citizens, privacy of homes, privacy of correspondence. Telephone conversation can come with all these things. Telegraphic can come with it. And we've had a couple of decisions on these forms or these fragments in Section 37. We all know Wali and Ebonyi State Electoral Commission. That's where the only case where privacy of citizens was defined. Even I would say that, it might look elaborate because so many factors were touched. And I think the court left it open. The court interpreted it liberally and expansively to include privacy of citizens, their body, their life, their persons, their thoughts, their belief, conscience, feeling, views, decisions, including plans and choices, desires, health, relationships, character, material possessions, family life. And the court said, etc., leaving it open. Anything that touches on human seclusion, human life, and touches on human information was left open. So people argue, a lot of people argue, Section 37 cannot take care of many privacy. They even say it cannot take care of data protection. They say it cannot take care of information privacy. This privacy of persons is open-ended. You can use it to argue any form of privacy. In my book, I wrote so many types or forms of, taxonomy of privacy, typology of privacy. So many. There's sexual privacy. There's associational privacy. There's relational privacy. All sorts. And that's where you will see that privacy is life. Privacy touches on everything. There is spousal privacy. Privacy between husband and wife who are meant to be one. There is family privacy. And there's also the family life. You can see family life. Family life is wide. That is another thing we have not really litigated in Nigeria. Family life is not individual. Family life brings in all your family members. And when you want to extend it, when you want to make it elastic, you will even look at extended family members. Now, this is in Wali. The privacy of homes, so many decisions on privacy of homes. But the ones I decided to talk about, Ibrahim and COP, police evicted. That's another thing. We hardly see eviction from the prism of privacy of home. Even there's a Supreme Court decision. Unfortunately, the lawyer argued extensively on how the court should see eviction, unlawful eviction, as an invasion of privacy of home. Supreme Court did not. And we need to do more with our understanding, with our approach to privacy. Supreme Court said no, that this is strictly trespass to land, what's it called, recovery of premises. But if you unjustifiably invade my home, that touches on privacy of home. But the Court of Appeal agreed here that when the police forcefully evicted a man, the Court of Appeal agreed that the privacy of home was not respected and it was invaded. Another case, Ibrahim and Nigerian Army, another quite interesting funny case. An army official cohabited with a junior officer's wife in his home. And the court held that the privacy of home of that junior officer was invaded when the senior officer went to Colombia, the man's wife at home. Now, the privacy of correspondence. This one, we also have a couple of cases on privacy of correspondence. Now, there is one which is also interesting, Absent and MTN. MTN swapped the line of Absent director with somebody else. They swapped the line, and the court held that was an invasion of the person's privacy of correspondence. Court of Appeal affirmed it also. Now, information privacy, data protection, like I said earlier, they can be tapped or they can come under privacy of citizens, which is wide, which covers every privacy interest that you can conceive. That is my opinion. Then, in the case that I modestly litigated, at that time too, we didn't have any decision on data protection. And I thought, oh, it would be nice for the Court of Appeal to decide this decision. So we went. It was NIMC. NIMC, Mrs. Adiza was here yesterday. NIMC said, if you want to correct your name or any information, you have to pay. And we said, other data protection, this is a right. We don't have to pay for rights, except it's excessive. We went to the Court of Appeal. We went to the High Court, we lost. We went to the Court of Appeal. We lost also, but the Court of Appeal mentioned the nexus between Section 37 and data protection. And that was all we wanted, actually. But because the Court of Appeal thought we would be reducing the federal government's revenue if we continue to argue that they shouldn't charge fees, because there's some requests that NIMC say people make some requests, some very funny requests with respect to rectification of data. So that is it about the decisions that impact the right to privacy. Thank you very much. Let me see if we have questions before I hand over to Moji for our own session. Okay, my book is, somebody's asking for the title of my book. It's called Privacy and Data Protection Law in Nigeria. So someone is saying, can we litigate privacy and data protection at the same time? Well, it depends on the process. So if you are going by writ of summons, you can put everything together. At least the High Court will have jurisdiction to hear data protection, and you can impute privacy. People are allowed to bring in causes of action, more than one causes of action, especially when they are related. And you can as well file two cases on different causes of action. Sometimes the court can consolidate if they are in the same court. But if you are in different courts, I hope they will be making an argument that you are what's it called in law now, that you are litigating to apart from abuse, that double jeopardy kind of. I mean, it might just be an argument that the other party can make. Now someone says that the name of the person in the IVF case was not mentioned And that relates. Oh, in the IVF, the name was mentioned, the identity was mentioned. So, I mean, the woman was clearly identified. And again, this touches on what we've been taught about data protection from the beginning. Data protection is not just about name. You might not mention somebody's name, but you might mention information that would identify the person. You don't need to mention the person's name. If you want to make anything about our president now, President Tinubu, you don't need to mention his name. Just put his cap there and say something. Almost everybody knows you are talking about Tinubu without necessarily mentioning his name. So there's so many facts, so many information that can identify. Any information that can identify is protected under data protection, maybe not necessarily privacy. Now, someone says, what is the place of privacy and blackmail using actual facts? Yes, those are some of the interests I have said, but blackmail, we all know blackmail is a crime. So you might just want to litigate, want to prosecute that as a crime, apart from just privacy. But again, the interests I have mentioned, I have spoken about, they address private facts, whether for whatever purpose it is used. Can a child be said to have such a right? No. So parents, they make such decisions, but there's this new decision where the court said that even if parents refuse blood transfusion, the court can give such order where the hospital or whoever is concerned approaches the court. So even if the parent says no, the court can give such order. Yes, the slides will be made available by NBA after after today, maybe by next week, we'll start getting the slides. If a photographer posts the person's picture without the person's consent and knowledge for advertisement, yes, now this thing comes under the use of image, or likeness for commercial gains. If a photographer uses, that is where copyright and data protection will clash. If you cannot use my image for commercial gains without my consent, that's a violation of privacy. So you will before you can use your own. It's just like somebody owning a house, a land, and somebody owning a house. They are competing rights. I know that the decision that says who owns the land owns the house, owns everything on it. But the person sometimes is okay. The person can be allowed to take out whatever he has. So this is where it clashes. I have commissioned you to take a picture. I have paid you. You have earned money from that taking that picture. You cannot now, to my detriment, use it without my consent. That would be violating a fundamental right. What you have is a contractual right. What I have is a fundamental right. Fundamental right trumps contractual right. In most cases, there can be exceptions, I agree, but in most cases it does. Now, if an artist features a company building in his music, does the company have a case in privacy? Oh, of course, artists would have to, they need to sign this documentation. You can't just use somebody's house for your music without signing. There have to be documentation that they sign to give them certain rights and that they pay for. So I think it's a violation if you use without consent. The use of AI-generated images, does it constitute likeness? Of course it does. That image, so long it identifies you, even caricature. There's a current decision of the UK court, First Tier Tribunal Court, that what's it called? Vestige. I've forgotten the name it is called. There is this thing that is taken from pictures. When I get the name, I'll send it to you. The name of the case is Clearview. Clearview and the Information Commissioner Office. There is this thing they get from images. I've forgotten the technical name they call it. Somebody has an image, like a drawing, like a caricature or something. The court said they are biometric data. Because if you take your picture and somebody takes the likeness of that picture or something, because they are biometric data and they are sensitive data, which is protected under data protection. So anything whatsoever that identifies you On LinkedIn, there was a lady that was one of my connections I reached out to. I mean, I saw a picture. I saw the jacket she was wearing, a very fantastic jacket. I didn't know the picture was AI generated. I reached out to her privately and I said, please, if you can give me your plug, I'd like to get this for my wife. And she just told me it was AI generated. The picture looked like her very much. You would some AI generated pictures, you would not even know they are AI generated until you are told. And the moment, the fact that they identify the person, they are the person's personal data, even though they are AI generated. Someone is asking, how do we educate judicial officers to be knowledgeable about data protection? First of all, it starts from lawyers. We have taken many matters to court. Sometimes we will lose, sometimes we will win. Sometimes it will take a whole lot of extra work to convince the judge. But I believe judges also know that there are certain areas of our laws that have not been explored. So if you have a case like that, you take it to the court and give it all the necessary materials. The judge might read it and agree with you, and the judge might read it and not agree with you. But sometimes it starts with the lawyers. The judges cannot take cases to their own court. It is the lawyers that will take it there. So when we see causes of action that look like what we want to do, then we just go to court and see whatever the court will say. Please, is there a difference between privacy and data protection? Oh, of course. Privacy is the wider scope, has a wider scope. Data protection is information privacy. It's that branch of privacy that deals with the use of information. Apart from information, there are other interests that privacy protects. It protects people's body. Your body is not your information. It protects your home. Your home is not information, except your home address. It protects your space. Your space is not necessarily your information, except it becomes your WhatsApp group and whatever. So data protection is just a fragment of privacy. Privacy is the bigger one. Data protection is a branch. I think, what mode of commencement do you strongly recommend to litigate data protection breaches? What are the pre-action protocols? Does the law require a report to the... Yes, I think part of the things still we discussed, honestly, we cannot give a straight answer because the law has not been tested. The courts have not decided. But I've done a case on the NDPR where the lawyer on the other side argued that there was a condition precedent before we could approach the court, that we should first of all approach the regulator. The court agreed with them, coincidentally. That was the Federal High Court. But I defended another case before the State High Court, Justice Harrison, and I made that argument. Justice Harrison said, no, it is not a condition precedent. Under the new act, there is no provision that says you must go to the regulators first. The law gives you the right to get damages for data breaches. The law gives you the right to approach the court for remedies. And sometimes you can also approach the regulator. So the mode of commencement, for me, I would always view it as fundamental human rights and go under the, because our first relief in most of the cases we'll be filing will be a declaration that data protection is subsumed under privacy. Although the Court of Appeal has ruled that we don't have a problem with that. And even the new act says part of the objectives of the act is to protect privacy. So for me, I would litigate it around privacy. And except we now have issues that cannot be analyzed by affidavit evidence, or that cannot be decided by affidavit evidence, then we will now say we want to do the writ of summons. But normally, because it is privacy, we would always want to go by fundamental rights. Now, intellectual property rights, this training is not intellectual property rights, so I'm not going to speak on it. And I won't even pretend to know intellectual property right that much. And I think there's an argument on liabilities around AI-generated materials on IP. Please, do I have a cause of action if my photographer posts my picture on social media without my permission? That was exactly what happened to me at a point. And I think, yes, you have a cause of action because you have a cause of action in privacy, actually, except you have signed documents. This happens with very established photographers. They will give you documents to sign. where you are licensing or you are assigning your rights in those pictures to them. Sorry, photographers are even the authors. They are the authors. So in terms of intellectual property, photographers own the intellectual property. But privacy, before they can use it, except you assign, you give them permission, you consent, otherwise it becomes an invasion of privacy. I think that's it. My time is, we only have 7 minutes, and I don't want to hit into Moji's time. There's no other question that I can see. Yeah. Okay, so I asked if agreements can be used to waive rights ordinarily conferred. I know there are decisions that fundamental rights cannot be waived, and I know there are decisions that say fundamental right can be waived. Maybe this is another conflicting area of our law. But in terms of privacy, once you give consent, as far as privacy is concerned, and there's a court decision, once you give consent for people to use your picture or your house or your information, then even under the Data Protection Act, it is a legal basis. The person who is using it has a legal basis to use it. So it's one of the grounds for someone to use your data. How can authors violate their own rights in line with your comment of photographers? How can authors are not violating it? Authors are only violating privacy. They are not violating intellectual property. There are two rights in a picture, or even more rights. There is the intellectual property of the person who created it. There is the privacy right of the owner. It's just like, let me give you an example. You are using video. You have a video. You are the one operating the video. You video the nudes. You capture the nudes of somebody on video. You are the owner of that right. Intellectual property. It is your creation. You use that nude to create. Can you publish the nudes without the person's consent? You can't. It violates the right, and in that case, that right trumps your own intellectual property right. So two rights are in what do you call it now? Are in conflict. Two rights are in conflict, and the law will balance one over the other. Nigeria has not signed Malabo Convention. How can NDPC adequately protect privacy rights of Nigerians? Malabo Convention is not even the one that protects rights extraterritorially. It is the NDPA, that gives that extraterritorial enforcement of data protection. Malabo rights only talks about framework for companies to have framework. And don't even forget, even if Nigeria signs the Malabo Convention, if we don't domesticate it, it is not enforceable in Nigeria. But so it is not also enforceable in the country where you want to enforce it if it has not been domesticated. So Malabo Convention is not even as important now than right now. It is enforceable in other countries in Africa, but Nigeria, it is not, because we have not ratified it. We have not ratified it, and we have not domesticated it. But the convention, the NDPA, makes provision for extraterritoriality, but it is yet to be tested. We don't know how that will happen, especially for countries that do not even have any presence in Nigeria. Although we are exploring it, some companies have been taken to court already, and we are hoping to see what the court will say about them. How would you assess? How can, where employers of the company attend an official event and take picture, can the PR unit list the pictures on the company's website? So these are things that will be, sometimes I always advise people not to use employees' consent. Sometimes it is the internal privacy policies that will dictate this, internal privacy policy of the company, or other documentation that the employees might have signed in the course of either recruitment or in the course of providing their services within the company. But I have always advised you can't use consent, because the employee can take back the consent. except you are able to tie it to the employer's legitimate interest. That yes, so legitimately the employer can use it because it's tied to our company's activities or tied to our company's business. Now, employees of a company attend an official event. This is similar to what I answered. Consent is not always workable. Legitimate interest is workable, and sometimes privacy policy, where you will say that the employees have been notified ahead of time that even coming into this company, we do periodic events and we use employees' pictures. But again, you won't want to use consent. You would use legitimate interest because you would say that the employees had legitimate expectations and understanding of that. I see Moji is getting ready for our session now. Where employees of a company attend. Okay, I think that is similar. Please, I wouldn't want to hit it to what you said. Can it? Yes. Vaccination in COVID, yes, it impacts privacy. But the government, they have legal basis. That is public interest. That is even your own vital interest. Vital interest of a third party. They are also so they have some countries already passed laws for this mandatory vaccination. So yes, there's a legal basis for that. How can lawyers acquire skills? Oh, there are so many training centers that you can attend. Where I gave an example of the Privacy Academy yesterday, and there are so many other training centers too you can attend. Please, thank you very much. I can't take all the questions. I see them pouring in. I'm sorry, I can't take all of them. I'll have to yield to Moji. Moji, thank you very much. You have the floor. Moji, you need to unmute.
Thank you, Olumide. Well done. So, okay, so what I was trying to do was to just be sure that my presentation can be seen on the other side. Good afternoon, distinguished Learned Silk, senior colleagues and colleagues. It's a pleasure to be here this afternoon to speak with you on the cross-border transfer of personal data, the dynamics and regulations. And I note that that should be done within the next 30 minutes. So I would try as much as possible to stay within course of the time. I don't know if my presentation is Olumide, is it showing over there?
Yes, it is. Yes.
Okay, so it's moved to the second slide, right?
Yes, it has.
Okay, thank you very much. Okay, so the overview of what I'll be speaking about, the definition of cross-border transfer of personal data and its nature, then organizations involved in cross-border data transfer. This really, the second point really is all about the nature of some organizations so that they can help determine the way a lawyer, for instance, is going to approach seeking redress for any form of data breach. Then we have the legal frameworks, and I will be limiting myself to the NDPA and it's the other frameworks. Then the challenges and the implications. So first and foremost, we know that the evolution in technology is not, has moved from child's play, you know. Gone are the days when you say, what you don't know will not kill you. Even if you had believed that word before, right now, what you don't know can actually be your, can actually be a death sentence on you. And I would use that example from Olumide, appearing in an EFCC picture. And then there is an assumption on the part of anyone who is reading the paper, always reading the news, and then they say, oh, I know that face. Is that not Olumide Babalola? Oh my goodness. So it was in EFCC's custody. You know, people would have such assumptions based on what they see. And then for cross-border, it's always interesting because you think you are, okay, you're moving with the times, you are downloading applications, you are entering into relationships, buying softwares, asking, developers, going on Amazon, for instance, and using their platforms. Everything looks so, how do I put it, innocent And so that is what happens with the use of the smartphone. The smartphone has given us this access to the internet. We can now, use whatever we want. We can download any kind of app that we want. In fact, some people have been downloading the AI app, which allows them to modify their pictures. So you see that this going around on social media, e.g. Facebook. In fact, I am a victim of my nephew's indiscretion. He saw the app, he picked my picture, and then went ahead and used my picture on that AI app, and then sent those pictures to me. Now, interestingly, as I saw those pictures, the first thing I told him was, did I ask you to do this? Because I knew the implication of sending my picture on an AI platform. And then we can, further discuss in this training. So what is this cross-border transfer? So it involves you sharing your personal information. Or how do I put it? When personal information is shared amongst or between national jurisdictions. So because of the way the technology is moving, it's a seamless process. It just takes a click, as we say. So you see where a data processor, for instance, or a data controller collects data and then moves it to maybe, for instance, a subsidiary in another country. And then they use, the idea is to use the information which the data controller has been able to, to collect. And then from there, you do not know. For instance, it's possible that a data subject will not know that their data has moved from one place to the other. And I'm sure that happens a lot for us in, let me put quote and unquote, in third world countries, or let me put it in Nigeria, because a lot of people have used different applications. For instance, you've used it without knowing that some of these applications, or most of them, they use your personal information to function. That is how to put it. They use it to function. And not only do they use it, they track and generate your personal data in most circumstances, such as location, such as your contact, such different aspects. And so when we talk about transfer, cross-border transfer, we're talking about the collection, we're talking about the storage, we're talking about the processing. And so when they are processing and collecting and sharing, we become, or the personal information or personal data becomes vulnerable to attacks, vulnerable to different aspects, even unsolicited advertisements, several implications for that kind of action. So what I've done is to give more information on this particular slide, so you can go over it again. So issues like individual privacy will arise, issues like security, confidentiality, legal compliance and protection of data. They arise when we're talking about cross-border transfer of data. And then, of course, when I was saying that there's vulnerability of data, I mentioned that, for instance, we can talk about cyber crimes. And there is the issue of fraud, security hacker. We have phishing, which is even very prominent today. For instance, I have been researching on online gender-based violence. And one of the things that I've understood is that phishing is a very veritable tool in the hands of the perpetrators. So we have all these, we have the cyber espionage. And because of these issues, a lot of jurisdictions began to put in place processes, laws, data protection laws to protect their nationals, to protect them, their security, their information. And of course, this is the right way to go, considering the gravity of having this information all over the place. Now, what are the purposes for cross-border transfer of personal data? It's not as if everything is bad news. Of course, we know that sometimes you need it for international transactions, communication and collaboration. For instance, multinational companies, they may have different subsidiaries everywhere, and they think that the best way, or the easiest way is to transfer data from one company or company in one country to the other. Now I can give an example of MultiChoice. We have MultiChoice Nigeria. Let's say MultiChoice, which is based in South Africa, decides to do a big promo, for instance, and it says, oh, this promo I'm doing, I want to do it across board over every country where there is a MultiChoice. And then MultiChoice Nigeria just feels that, oh, we have had good, let's say, we have had subscribers, people who have been very faithful over the years, who always pay for their subscription. And then they say, oh, let us advance these people's information to our mother, our mother company, for instance. In that circumstance, we see that they've shared the personal data. And then the question that will now begin to arise is, at the time that they were sharing the information, did the data subject, for instance, consent to this, sharing of information between a company, for instance, and and its subsidiary? I'm just, for instance. So, but they may have a very good reason. They may have a valid reason for such a transfer. And then, of course, with the transfer of data or the evolution of technology generally, we know that the benefits are economic growth, health, safety, and the common good. And, these are just general things that, benefits that we can actually see with the evolution of technology. And who are these people who actually use our data, personal data? So we are looking at organizations acting as either controllers, joint controller or processor. So we have the processors in also. Then, of course, the general word, which are digital service providers. And we know digital service provider is so broad and covers a lot. And I've tried my best to also explain for that, because I would not be able to go in depth, following my slide as I've prepared it. So we have, for instance, online marketplace. We have cloud computing services. And then, of course, I just decided to add applications at that point. Applications, the ones that we keep loading on our phones or smartphones and gadgets. So deliberately put it there because who are these organizations? Controller, the processor, and understanding of what they are. Who are they? These are services like online search engines, marketplace or cloud computing service, hosting software development, and still went ahead to put cloud computing services. We have the SaaS, the IaaS, and we have the PaaS. And interestingly, if it's good to understand the nature of these ones I've just mentioned, SaaS, IaaS, and PaaS, because it also helps to determine the kind of the nature of liability that you can attach to them whenever they breach your rights, whenever they violate your rights, against your privacy or use of your personal data without your consent. So when I described those SaaS companies, SaaS companies are software as a service companies. I deliberately owned on SaaS companies. I believe that as lawyers, we can do more research on IaaS, which is infrastructure as a service. And then, of course, PaaS, platform as a service. So we can go down into those, each of them. For SaaS, there are companies that deliver services for a consideration. So they exchange their service for money over the internet. These companies, they actually may have, for instance, opportunity for you to have the free version, but they are majorly established to make money from the services that they're providing for you. So in this instance, you have nothing to worry about. Everything you need is on their platform. The software is updated by them, is upgraded by them. They determine how to install the software. They are in total control. So for instance, I've been using Dropbox for how many years? I can't even, as long as I've been using Gmail, I've been using Dropbox. And Dropbox has a lot of my personal information up there because I keep using it because the cloud, service. I kept putting a lot of things there until it became full. And that information has been there. It has been full now, I think, for more than 7 years. And I keep getting the update that, oh, you can upgrade, you can upgrade, you can upgrade. And I've not upgraded. And my information is still there, being kept in this cloud service. And the question will now be, what will happen? For instance, I never go back to it. What happens to my data? Why is it, my data will just sit down there and will it just be there? Or one day, let's say that the NDPA will be able to apply, So I've given examples of companies that are under SARS and it's elaborate. And then, of course, companies that are not SaaS, that look this as a software as a service company, for instance, and it is not. But LinkedIn is, because LinkedIn was created, to have, from the moment I want us to just go to the legal framework because I'm aware that I don't have much of time. So the legal frameworks, I listed the Principal Data Protection Legislation, which is the Data Protection Act 2023, then the Nigerian Data Protection Regulation 2019, then the NDPR Implementation Framework of 2020. Now, the way the NDPA operates now, it embodies even the NDPR and the implementation framework. And that may look like, how do I put it, a progressive approach. But however, we know that there may likely be some conflict between that the NDPA and the NDPR, maybe based on the kind of provisions that are in it. And good to know that the NDPA has been able to has put a prevention measure in that it says where there is conflict, the NDPA will always prevail. Now, for cross-border data transfer, there is a similarity between provisions in the NDPA and the NDPR. And so, except for I noted that there is that part in the NDPR whereby, when you want to carry out any cross-border transfer of data, you need to get the approval of the Attorney General of the Federation. And that is listed there. Okay, so key terms that are very important whenever we are talking about cross-border transfer of personal data. We are talking about personal data itself, which of course you have to be able to know and define. You have to put it in context. What is this personal data? Then of course you need to put also in context what is or who is a data subject, and then what is processing, and of course data controller and data processor. Also, those are important terms that we should not take our minds off anytime we're thinking about cross-border transfer. Now, according to Section 2, sub 2 of the NDPA, the NDPA will apply to businesses established in other jurisdictions, where the businesses are involved in the processing of the personal data of data subjects in Nigeria. So this is a good provision because it is clear, and it says that, oh yes, we are going to apply in any form of business that is happening in every other place, even outside Nigeria. So as it is now, the Act permits the transfer of personal data to other countries. But there are two things that we have to put into perspective every time we're thinking about the cross-border transfer of data as provided for under the NDPA. And that is the adequacy provision and the issue of derogation. And derogation, I'm talking of the exceptions. And in this particular, for these, we have section 41 to 44 covering cross-border transfer. So generally, the data processor and data controller, they are under an obligation to provide to the Commission a general description of the risk, the safeguards, security measures, and mechanisms to ensure the protection of the personal data. Now, because the Commission is empowered to actually provide such guidance or to have such information, it means that there is accountability, or there should be accountability, and there should be what? Transparency in any form of transfer of data from Nigeria to any other country. Section 41 of the NDPA, now it provides that personal data can be transferred outside Nigeria, where the recipient of the personal data is subject to a law binding corporate rules, contractual clauses, code of conduct, or certification mechanism that affords an adequate level of protection with respect to the personal data in accordance with the NDPA. So the adequate level of protection as provided for by the Act means that the capability or sufficiency of the data protection mechanism in place in that recipient country is very, very critical. So it's not just that how do I put it, that there is a mechanism in place. Then it means that that mechanism that is in place must actually be in tangent with the NDPA. It must be sufficient, adequate, to protect this data subject. And data subjects I've already defined it. So the Commission has the responsibility to determine this capability or sufficiency of the data protection mechanism in place in the recipient country. And this it does, or it should do, because I'm aware that it hasn't, by issuing guidelines that would measure compliance. And then, when these guidelines will not be the ones that, for instance, in addition to the provision of Section 42 and other provisions covering this section, these guidelines will also direct the way in which this a data subject, for instance, can understand. For instance, you want to go and seek a redress for your right, you will be able to see whether this company or this company in this country has complied substantially with the data protection in that country, and that in that country that is also in tangent with the NDPA in Nigeria. For instance, there is this case in which Ireland, the Data Protection Commission in Ireland, where it took Facebook, where it slammed on Facebook 1.3 billion naira. Sorry, I'm so sorry, $1.3 billion as fine. And that was because there was an issue of the data set of Facebook users. We are talking about 533 million users. The data set was found on a site, which is a hacking website. And immediately, Ireland, for instance, took that case up and said, no, you are fined. And the last I knew was that Facebook said they were appealing that fine that was placed on them by the Ireland Data Protection Commission. So that in itself gives me this kind of joy that if we can have a situation, identify the breaches by corporations like Facebook, whether Facebook has been sharing our information in Nigeria with the United States for a long time, like they did in the Ireland case. In this Ireland case, they have been sharing information in the EU, the information of EU citizens, that's Ireland, for instance, and they'll be sharing it in the United States. And this commission says, no, you can't continue to do that. It is not permitted. That is in their own data protection provision. So if we have the commission that can be that proactive, for instance, I know that at some point was it NIDA tried to or they did take a case against Truecaller because they found out that the privacy policy of Truecaller infringes on the provisions or breaches the provisions in the NDPR, and they took this up, and and I do not know the outcome of that particular case, but I know that in itself shows that if you have a commission that is very proactive, for instance, and it is very up to date on issues on transfer, then we can have a sort of modicum of control over the personal data transfer that is going across our borders. Now, when we're talking about this level of adequacy, I'm going back to adequacy, it says that the cross-border data transfer must also substantially comply with the principles that are already established in the NDPA we really talk about data, personal data, and processing of personal data. And those are, I'm very sure they have been taken during the week by other presenters. And that's, for instance, those are the issue of fairness, lawful, transparent, that the collection of data must be specific, explicit, must be adequate, relevant, and others, and then minimization of data and all. But I want to go to now is section 42. So when we are talking about cross-border transfer, there must be an availability of enforceable data subjects' rights in that other jurisdiction, and the ability of that data subject to enforce such rights through administrative or judicial redress and the rule of law. So this section 42, gave an outline of so many provisions that must be adhered to, and existence of any appropriate instrument between the Nigeria Data Protection Act and a competent authority in the recipient's jurisdiction that ensures adequate data protection. Then access of a public authority to personal data, existence of an effective data protection law, existence and functioning of an independent, competent data protection or similar supervisory authority with adequate enforcement powers. And adequacy of international commitments and conventions binding on the relevant country and its membership of any multilateral or regional organizations. However, even though these are clearly laid out and specified, there are certain circumstances that even the NDPA recognizes, whereby if adequacy may be, how do I put it, may be subverted. So this exception or derogated from, and this, it says where, for instance, the data subject has provided, a consent and then has not withdrawn that consent, and that consent is, to such transfer after having been informed of the possible risk. Such a data subject has been informed of a possible risk of such transfers, and with this information, the data subject still goes ahead. I can use an example where we download applications, for instance. We decide that some of us do not read those long things that are written there. Some of us will read the permissions. And despite the permissions, even when we know that the permission will say, it will read your contact, it will read your location, it will read your it will read, different things that it is to use your camera. We still go ahead at any point in time to say, okay, I consent. In fact, I can almost bet that as lawyers, we might have even seen a particular application, third-party applications, and we still go ahead and consent in that kind of circumstance. Now, using and sharing our data, personal data, across borders, most times, in fact, these applications are not even applications that are even developed in Nigeria. we have, for instance, it was during, this, how do I put it, this desire to know more about data protection and privacy that I started discovering that Jumia that we've been using over the years, of course, was created, for instance, in Germany. And we have Bolt. Everybody, we are all using Bolt, and Bolt was created in Estonia, and Truecaller in India. So these permissions are there, for instance, and even with companies in Nigeria, for instance, that are using software. We have some that they need a third-party developer software to function, or they use a third-party company to function. For instance, let's say Uber, for instance. Uber has some drivers, there's an agreement with drivers in Nigeria, and then Uber decides that, okay, he wants to start this reward system. And then it decides that, okay, this reward system should be handled by an HR company, and the HR company is based in France. And so with that, because he has a database of drivers, he has their phone numbers, he has their names, he has details of their accounts, and then he just goes ahead and just transfers it to France, because the human resources company is in France. And then he does that, and then that is it. Cross-border transfer has taken place. And so we have issues like that. But in this exception, that those ones can be clear breaches, that scenario that I've just created. But now let's imagine that at the time that these Uber drivers were entering an agreement, they had entered this agreement that at any point in time, your information may be shared with a third-party human resources company, for instance, or, and then your personal data will be processed. It will be in their hands, In this kind of circumstance, you are aware of this. And then, for instance, Uber decides again to give out an information, say, okay, we are transferring the reward system we are doing, we are going to go ahead to transfer your information to a third party, or they might even decide not to tell you. And then the issue will now be, as cross-border transfer has there been a breach of cross-border, has there been a breach of the provision of the NDPA in section 41 to 43, 44? And then, of course, we have another exception, which is that when transfer is necessary for the performance of a contract to which a data subject is a party, or in order to take steps at the request of a data subject prior to entering into a contract. So this Uber issue will fall squarely and comfortably in that particular situation that has to do with contractual obligations and contracts in general. Now, then of course we can another provision under that section 43 is the transfer is for the sole benefit of a data subject, and it is not reasonably practical to obtain the consent of the data subject to that transfer. And if it were reasonably practical to obtain such consent, the data subject would likely give it. In this particular provision, I'm a bit wary about it. This particular one, I'm a bit worried in the sense that the vagueness of it, because there can be many reasons why you cannot, for instance, that a data subject cannot be reached, for instance, to give consent. And so my worries will be, how do you now say reasonable practical? That one will now be left for the court to now try to determine what can be defined as reasonably practical in this kind of scenario. And then, we do not have those kind of cases yet, even as much as we want to, but I trust Olumide Babalola is always on the move to try out every, and that's a good thing. Then, of course, also under the exception is if the transfer is necessary for important reasons of public interest, and the transfer is necessary for the exercise or defense of legal claims, or the transfer is necessary to protect the vital interest of the data subject, or of other persons where a data subject is physically or legally incapable of giving consent, or a general description of the risk. Oh yes, sorry. So that is incapable of giving consent, full stop. So I just stated there that I deliberately put that general description of the risk, safeguard, security measures and mechanisms to ensure the protection. This is contained in section 44F. That particular one is that when the commission requires the data processor and data controller to provide necessary information. Now, what are the challenges that I have noted? And just basically, I look at the capacity of the Nigerian Data Protection Commission. I look at it. What is this capacity? As in, are they funded enough to take up this fight? I know that this is a big, the internet, the environment itself is huge. The environment of the internet, of this internet space is so huge that I know that every day, every hour, in fact, as I'm even speaking right now, cross-border transfer of personal data is going on, and it will not be complying with the provisions of the NDPA. Now, what is this capacity of the commission? How can they effectively monitor and oversee this huge data that is going around? So this raises questions in my mind. How possible can they, be that efficient? And then, of course, that would also now raise the issue of enforceability and implementation. Is this going to be a provision that is just those kind of provisions that it's so beautiful in the Gazette, like in the law as it is, we can say it exists, or will it be implemented over the coming years? Are we going to be able to achieve some form of implementation? But I know that even if we cannot reach every angle of the country, for instance, if we can reach a substantial level of holding some multinational companies responsible, that can actually be a win-win. May not be a total win, but at least we say, oh, we win, but at least that keeps us thinking. Then, of course, the multinational companies themselves, they deal with a lot of international partners. That was one of the reasons why I deliberately inserted in here the software as a service and the infrastructure as a service, platform as a service, for us to just look at them and actually look at their nature and the characteristics of all this, and look at, the kind of role that they play, roles they play when we are talking about multinational and the cross-border markets, global markets, what they have to do in terms of relationship with multinational companies, and every other circumstance around them. So how can they comply with the data protection in all jurisdictions? So these are issues that I was thinking about. And then, of course, I said that ultimately the implication of having the provisions on cross-border transfer, is that we have, I want to believe, increased privacy rights, for data subjects. And then we have consent and choice, which allows data subjects to maintain a level of control over their virtual decisions. So if I am dealing with multi-choice, for instance, and they give me a form, they give you these forms, and these forms, you see these fine print, very tiny things. I actually complained about such yesterday at the bank, because I was like, okay, you are giving me this form to just apply for a new ATM card, and then in between of me writing my name and then signing below, I'm seeing this tiny, and I told them, I said, do you want me to come into the bank with my magnifying glass? If you want me to always do that, I will do that, because I don't know what are these things that you have put in this tiny write-up. So, it also shows that multinationals, it also shows that even the data processors and controllers, there will be measures that they would do, there will be ways that they would try to do to make it onerous for data subjects to actually go through all their policies, for instance. When you are downloading an app, for instance, can we actually say, every one of us on this call, can we actually say that we have read word for word every provision or every policy before we download it. Can we say that? That's a question for all of us. But when we have a provision like, the NDPA, it shows that we can actually take more active steps to protect ourselves. And then as lawyers, for instance, give appropriate advice to our clients. Then I look at another implication of Section 4144, and that is the availability of data breach protection and mechanisms. And then, of course, we have the improved organizational security. And that one basically is that multinationals will now be on guard in the sense that they don't want to be caught on the infringing side. So they will take more caution providing security for the personal data that is in their custody. So you see them taking up firewalls, or how do I put it, these enough security options to protect the data subject. And that, of course, is hopefully, it may not be every organization that would achieve that, but at least a substantial number, knowing fully well that there is a data protection law in the country. Then, of course, there is that increased cross-border data transfer accountability and responsibility. And that is one of the, how do I put it? It's a futuristic hope, or should I say expectations on my part, that okay, there will be accountability, and then there will be transparency and responsibility when multinationals or data processors and data controllers, they are dealing with our personal data, so that way they can protect data subjects, and then they can also comply with the obligations under the Data Protection Act. And thank you very much. That is all for my presentation. I hope I had not rushed, but because I was told I had 30 minutes and I said I wanted to try and get to the end of my slide, but I believe the slide will be shared with everybody on this call. So let me see. Olumide, can you assist if there are any questions?
Thank you, Muji. Let me quickly read out some for you before we call it a day. Where there is an international data controller with a subcontroller and a breach of data occurs, its subcontractor or controller who will be held liable. I don't know what she means by subcontroller, but that's the question.
I think the person is trying to ask about that, this subsidiary issue, the major company and the subsidiary. And then the issue now will now be, who is the data controller and who transfer this data? That will be the first question that will come in. You are transferring data from Nigeria, for instance, with another company outside Nigeria, who, this person is calling a subcontractor. Let's say the person that is transferring this data first is the person who we should be looking at liability for. And I gave an example of the issue of the commission in Ireland, when they find Facebook Ireland. Facebook Ireland in the EU region shared the data set of the Facebook users in the United States. So who did the commission hold responsible? This was the Facebook in Ireland that would be paying 1.3 billion. So will the mother company, which is in US, pay for this fine? That is their internal issue. But the one that the commission was holding responsible was the data controller within the jurisdiction of Ireland. And so in this circumstance, if you are saying, for instance, MultiChoice, DSTV subscribers' information were shared with MultiChoice in South Africa, the first point of call will be MultiChoice Nigeria, not the other one over there. So I hope I've been able to answer that question. And if Olumide wants to add to that.
Does it constitute cross-border transfer of data where the server of a Nigerian company is hosted in another country, along with the staff data?
where the
server of a company is hosted in another country.
Olumide, I think I will leave that one to you seriously, because I'm looking at it from the perspective that it is still cross-border transfer. It is cross-border transfer. Because if the fact that it is hosted does not change the fact of, it is transfer from your own situation, your own locality, and then you're transferring, to that other website that is hosting you. So it's clearly a cross-border transfer.
Before I read out the other question, I think we should all disabuse our mind. The word transfer sometimes is confusing. I always prefer trans-border flow. There's some legislation that use the word trans. I have written an article published in one of the journals, and what you have is trans-border flow. Flow is easier to understand than transfer. When you say transfer, people will think you have. But once data flows from one country to the other, then the provision of the law catches that kind of flow. Now, where a data controller has consent of data subject to process data, and it goes ahead to anonymize or pseudonymize that data and send it to cross-border, does the anonymization absolve him of obtaining consent for cross-border transfer?
I don't understand that question. But I think that it's but you've already said that the company got the consent.
Yes. There is another one, is what Uber and Bolt is what they do. A transfer is data. I mean, the question is, Uber and Bolt, their business, does it constitute data transfer across borders?
See, there is, I think I put it there, the marketplace people, those who are, how do I put it? They are just pay as you go services. Now, Uber and Bolt, if you look at the situation between, let's say, between the Uber company itself and the drivers, and then these drivers always provide information. And I've seen situations also where you as a user, you actually provide information. For instance, I remember when I started using Uber in the first place, I was putting my bank information there. So for instance, I just took Uber up and I clicked on consent. I just said agree. I didn't read all these things. I didn't read it. So if Uber, for instance, had said that, for efficient performance of their services, they would need to transfer, for instance, data between themselves and a third-party company. Of course, we know that your data is moving, is flowing, as Olumide has said, it is flowing. And then the question now, the issue will now be, what would my banking information be doing in a third-party's possession, for instance? If that should occur, of course, there is a breach.
Now,
there is a breach. Despite the fact that I read their rules and agreed, I will still take it to court.
How can we confirm the availability or an existence of these requirements in foreign countries? I think the requirements you spoke about earlier. Did you get that? Did you get that question? Moji, is your network freezing?
Okay, no. I said any places that should be mentioning that is similar. Let me see as you're reading it. Is it back? My network is freezing, and I'm aware. I can see it on my screen.
Okay, so how can we confirm the availability and existence of the requirement in foreign countries?
So most countries now, I've said it, they are all, how do I put it? They all are putting in place data protection laws and regulations. So it is, if you're looking at how do you confirm, for instance, we are lawyers, it's easy. It's all about reading about their own provisions, for instance. And now, another problem will now be and you are very correct, how can, for instance, the NDPA or NDPC, the commission itself, how can they verify that Facebook in the US, for instance, has complied or has put on mechanisms in compliance with a US data protection law, for instance. They are wide, they are broad, and they are huge. And that is why I said, I don't know how practical these provisions will be. But the issue is that the main thing is that we now have this law in place. And verification I can't see it happening in the next 5. I'm sorry, I can't be pessimistic. In the next 5 years. But I know that when it comes to verification of whether a particular company is complying with the mechanism, I think that will now be a duty, for instance, on a lawyer who wants to represent a client who brings this kind of issue before them. It is now your own duty to now do a proper screening or research and investigate, try to find out what are the rules governing data protection, privacy, for instance, in the United States. When you find that out, then you look at the multinational company itself, read their policy document. You have to read their policy document to be sure that they have mechanisms in place. And in fact, even as a client, I think as a client or as a data subject, you may have to do your own due diligence. That is on a larger scale. And on a larger scale, I totally agree with you, Uchechi, that they usually disclose that they engage third-party service providers, and there will be, so there are so many dynamics to this cross-border transfer. And if I say that I am completely, as in, how do I put it, knowledgeable on this, it won't be. But I know that it's a working process, that we not even have the NDPA in the first place, that we are not just dealing with the regulation. And then this act has now stated that these are the provisions, these are the rules, and that's a plus. That is something to work with, and that's something that puts us all on our toes. I remember the yesterday's webinar, that the issue that the what's her name, Adiza, yes, Madam Adiza was saying is awareness. A lot of people are not aware. In fact, a lot of companies are not aware, and a lot of companies are even using software, third-party softwares, that are not even aware of what they should do. But NDPA is telling you now that you should be aware. But of course, NDPA, even the NDPC also has a responsibility of making sure that this information is everywhere. Everybody needs to know at every point in time, so that we can properly guide our partnerships, transactions, and relationships over the internet.
Thank you very much, Moji. Thank you very much for everybody who have stayed back, since the first day up to this last moment. On a parting note, the thing with cross-border transaction is you need to also work closely with the NDPC. Yesterday, someone mentioned it, and I think you might want to get just Google and you look for the NDPR implementation framework. In that framework, there is a white list of countries that the regulator has deemed what was the word we call them, adequate. Deemed their data protection framework adequate. There's an adequacy decision in their favor as far as Nigeria is concerned. So you can just check and see those countries. Then you can now, there's a white list. We call it white list here. So the countries are whitelisted, and from there you can see. Thank you very much once again. That will be the end of this training for data protection.